Yeah.
Oh my God.
I present to everybody.
That's like next
Everyone
time.
loves me.
Did I say that? Okay, then you.
We don't present at iPro.
Pardon me?
We don't present at iPro.
Thank God. Oh, now you can go to iCloud.
Oh yeah, iCloud, yeah.
Nobody cared. He said that I broke.
Okay, Carol, you know more probably, yes?
I'm done
about-
with Rico. I'm done.
Sorry?
I'm just done with Rico. Yeah.
Okay, I guess we're ready? Yeah? Okay. So Edward from Property Law, we kind of changed our logo last time I was here. We looked a little different. It's basically the same. Nothing's really changed. Just new colors and a weird slash down the middle. I don't like it, but some people like it, so whatever. So I'm presenting today on close without delay, common closing problems. Okay, so kind of things that we're seeing on our side in terms of deals not closing, because there's been a lot of that the past 2 months. I find, the past 2 months have been really great for us, but also really bad for us, because the type of files that we're getting are just terrible files. They just have not been smooth to close, and so we kind of go through what we're seeing, so maybe it can help you guys get a good idea of when you're going out there and doing deals, to either maybe try and help you avoid them, or just give us a heads up. Maybe we can help. I find a lot of times we can help a lot with a lot of things in advance, to whether it's clauses, whether it's situations, to give advice to the clients, and they have their expectations. That I always find in everything that we do, we're service providers. You, me, everybody along the path here, mortgage brokers. And when you're providing a service, one of the most important things is to set a proper expectation to the client. When they got their expectations set properly, whatever comes up along the way, it doesn't really matter at that point, right? They're not surprised with crazy things down the road. And the deals in some ways kind of go through things a little bit easier, I find, at least. Hopefully. Maybe not. Do I use this thing? Sure. No? Enter? Oh, enter, okay. So common closing problems we usually tend to see is, and we'll go through this list, we'll start at the top. So buyer beware. Everyone's heard of this term, buyer beware. Legal term of this is caveat emptor. So buyer beware basically means that a buyer, when you go into a deal with a buyer, they're taking on this property as is, where is, unless there's some other clause in the agreement that says otherwise, right? If there's no clause in Schedule A, they get the property the way it is. And then whatever's in Schedule A kind of adds to it, whatever that buyer wants. So you could have a home inspection condition, you can have a finance condition, whatever those things, and then you go and you do the home inspection condition, and you waive the home inspection condition, and then they come and say, well, I don't know, the roof is leaking. Well, was it in the report from the home inspector? Yes. Okay, so what do you want me to do now? It was in the report. I can't do anything for you, right? It's a buyer beware. They're taking on the property with its risks, whatever those risks might be. The place could fall apart if you didn't do a home inspection. The place could be structurally unsafe to live in. Too bad. That's what you bought, right? So it kind of setting that expectation with the client is like, do you want a home inspection? We should get a home inspection. Because if you don't get a home inspection, you take what you take. Whatever you just bought, that's what you get. It could be a pile of rubble tomorrow. That is what you get, right? A seller, for the most part, and there's some exceptions to it, for the most part, doesn't have to disclose anything to you about the issues with the home, unless it's something that they actually hid themselves, right? Those are called latent defects. So, if they went off, and we had this situation, it was a funny one actually, the basement flooded or had some sort of leak in it. And they went and they tore the wall down on the one side. It was beside a door. It was next to a door somewhere that's going into the basement. How they have those side entrances or back entrances. Whatever happened, there was some sort of flooding. They opened the drywall up, closed it back up, fixed whatever they claimed they had fixed. What you should always be doing as a seller is inviting the buyer to the property after the flood happens to let them inspect it, to see what happens. It's case law. Case law actually says, this isn't statute, this is a case that basically says, as a buyer, you should come in, you should look at the home, and you should decide based on the flooding or whatever the damage is. Could be a fire, could be flooding, it could be a number of things, right? Do you need to get further inspections done by maybe an engineer or someone else? You need to, as a buyer, be given an opportunity to decide whether you accept this or not. And then they can go off and start fixing it, right? So anyway, so these people never invited the buyers to go in and fix it. Closing happens. we knew that something happened, and they sent us photos on day of closing that it looked like it was fixed. They sent us like a nicely finished drywall with new paint, and it looked actually really nice. And I don't know, it was like 2 weeks later, the client calls me after some sort of rainstorm and says my basement's flooded again. And they opened up the walls, and behind the wall was open dirt. There was basically a hole behind the cinder block. It was like an old Toronto home, and the cinder block had deteriorated to the point where there was no cinder block anymore. It was just dirt. It was a small section. It was a very small section, but that's where the water was coming in. So these people purposely hid that, right? So you can go after the seller for that, because that's a defect that they purposely hid behind the wall. They knew exactly. So they must have opened the drywall to fix this leak and then never did anything about it. I think they put spray foamed it or something. They tried to fix it, but they didn't really fix it properly. So anyway, so you could probably sue the seller for that. So that buyer beware, right? Like typically, buyer buys what they get unless there's some other either latent defect that you can sue against, or there's some sort of condition in Schedule A that says X, whatever that might be, right? But typically, if you're getting a home inspection and that home inspection report didn't disclose something that probably should have been disclosed because it clearly shows that there's maybe leaking in a corner of a wall somewhere, you're not going after the seller at that point. You're actually going after the home inspector, right? So your liability goes against the home inspector, not the seller. So it's kind of, explain to the clients, we're going to get to home inspection, but if the home inspection doesn't report everything and it's something that they should have reported, just be aware that you're not going after the seller at that point, you're going after. And we usually set those expectations with the client sometimes. So everyone's used this condition 100% probably in almost all of their deals. It's basically the chattels and fixtures are going to be in good working order. Everyone thinks that this condition's this like glorious condition, magical condition that saves them from everything. It doesn't. So basically, there is the way it's worded in this specific scenario, because there's different variations of this, but like this one specifically is it's good working order. Where is it? Why can't I read it? On completion, right? So on the day of closing, the chattels and fixtures have to be in good working order. And that means that a client can't come a week later and tell us the fridge is not working. On closing, based on case law, is usually within a day or two after closing. You got to tell us immediately. So we always just tell clients, night of closing, go in right away. Just make sure everything's working before you start moving stuff in. And it's easier to prove at that point that nothing was, or something was broken, or something wasn't working, rather than you starting to use it 3 weeks later and telling us that something's broken. Same thing, scratches on the floor. It's easier to argue that sort of stuff on the day of closing with no one moving things in yet, than moving your things in and it's being like, hey, the floors are scratched. Well, who actually scratched them? You or your movers or the people that actually moved out? Like, no one really knows. So on completion really means like a day of closing, like that same night typically, okay? Even hard to argue the next day AC unit's not working or furnace is not working because it could have just broke that next day. Like nobody knows, right? So on completion literally means that. A lot of lawyers, we find, create a lot of problems around this clause because they don't know how actually this clause works in the case law, or probably know, and they just force a hand basically to the buyer. So what a lot of lawyers are doing, and I do this myself too, is we'll say, well, no, you agreed to buy the property, you signed this deal on April 1st, and on April 1st the AC unit wasn't working, but you never put any sort of condition about inspection or something like that. So that's what you get, because that's what you agreed to buy. Buyer beware, right? But legally speaking, because it's the clause, the anything in Schedule A trumps whatever the original buyer beware clause would have been. So this technically trumps that sort of argument. And we argue it, and we say, well, no, this specifically says there's supposed to be a completion, and it's not working. You might get like an inspection the day before, and we argue, we try and get some sort of credits back from the buyers or from the sellers. Yeah. And we kind of say, you agreed to buy, like this, the state of the property was this way when you entered into the agreement. And that's what you get. That's what you bargained for. And you go back and forth the whole day arguing over it. And at some point, someone has to give in. Because one, you're not going to go and sue over like a broken fridge. It's just cheaper to go and buy a broken fridge than to go and try and sue over it. So at some point in the day, someone gives in. And we usually call that hold back chicken. We all do this as lawyers. It's a game of chicken basically. Who's the one that's going to give in on the day of closing? Who really needs to move in? Who can like risk losing their deposits to argue over $1,000 issue, let's say, for example. So I find that creates a lot of problems. The truth of it is that this clause in holdback chicken, the way it works is that even if the fridge wasn't working and you didn't know as a buyer that it wasn't working, then this clause takes effect and the seller's required to fix the fridge. Whatever it might be. It could be furnace, fridge. Usually it's some sort of chattel. Usually it's like a, like if the floor is scratched, it's scratched. Like someone scratched it, they're supposed to fix it. That's different. But usually it's something to do with like a chattel. And I find that creates a lot of headaches for us on the day of closing. So, if someone, I always recommend if you go into the property and you know that the AC or the furnace is not working, don't rely on this clause necessarily, because this clause is going to create a lot of problems on the day of closing between two lawyers. I would actually put a new clause into the agreement through an amendment that says seller agrees to fix the furnace or AC unit before closing or something like that, or agrees to give a credit to the buyer of $2,000 to go and deal with the furnace or fridge on their own. Like actually address the issue, right? Because everyone now knows the expectation set that I got to do this. That's part of the negotiation. That's part of the deal, right?
You mentioned that, okay, let's say that something is wrong, and then even after inspection, and the seller decides that he will remedy, that he will pay for this. So then is there something still conditional that, let's say there was a second inspection when his thing is done, because he said, well, I will do it before closing, yes, but then you still,
See, it's not done.
So how you put an extra clause? How you address this issue?
Well, so you can try and negotiate, but a lot of realtors usually throw it back to us as lawyers.
Yeah.
And it goes down to the holdback chicken game on the day of closing, because now we got to figure out a number.
So you can withhold, for instance, or there's another way?
You can't unilaterally withhold money.
No.
But if you put in the clause that says that seller agrees to fix the furnace by closing, and if they don't fix the furnace by closing, a holdback of $5,000 will be provided. Then we have a route now to say, okay, well, we're going to just hold back the $5,000 until you fix it.
So that would be an amendment just before closing, because you've gone in 3 days before closing and you notice something's wrong, but then both parties have to agree.
Both parties have to agree to it, of course. You have to agree to it. So, and this is what I said. If it's not agreed between the realtors, it comes back to us, and between lawyers, we play the game of holdback chicken. Someone's going to give in at some point.
As realtors, we can try and get the amendment signed, but we may not be able to.
Usually the way I find this is that with realtors, between realtors, you guys have some sort of common sense. Between lawyers, well...
It's a very good expression.
Okay, so there's reasonableness in discussions between the people, right? Whereas with the lawyers, it's like butting heads. Everyone's just like, no, I don't have to agree to this. No, I don't have to agree to this. No, too bad. Sorry, this is what the clause says. Screw you. We're not agreeing to this, right? So it's that's why I say holdback chicken. It's literally a game of chicken on the day of closing as to who's going to give in. We sometimes go to like 4:30 in the afternoon arguing about this stuff. Right?
The words not merge on completion, you see a lot, but that's essentially meaning not disappear?
Yeah, it just basically means that it continues at some point after closing. So like if it didn't mention anything about not merge on completion, that timeline ends on completion, on the day of closing. The minute it closes the deal, that's it. This clause is no longer relevant. So you have to confirm that everything's working on completion. So you basically have to walk in on the day of closing before you close the deal and call your lawyer and be like, yeah, everything's good. And then we can close the deal. But the fact that it says not merge on completion basically means that it's extended past completion at some point.
But then why does the next phrase say apply only to
the property at the completion of this transaction?
At
completion, yeah. But this is where the case law comes in and says that you can have a certain period of time after closing to deal with these chattels. But they limit how much time that is. The courts basically say it's usually a day or two at the most. And it's kind of like they don't really give you an answer. It's like you like there's situations where they can have a week. But again, it's very situational based and it varies on what the issue is.
Because the word merge seems like something's coming together, but it's not coming together.
Yeah, it's basically it's not ending, is what. You can almost replace the word merge with it ends. It doesn't end on this day, this representation.
Do you feel like realtors get to a point, let's say before the closing, where they don't want to touch?
Yes, all the time.
And
Hold back chicken is what we end up
But
doing.
is there a time limit, or can we actually do an amendment like the?
I
night
personally,
before?
I don't know if there's some sort of limitation through RICO, which I don't believe there is, but a realtor can create an amendment at any point prior to closing.
That's right.
It could be the day of closing, you could create an amendment. I mean, logistically it doesn't make sense. It's easier for the lawyer to do it at that point. But like if you're a week before closing and you go to the home and you see that the home's in a complete mess, and it like something needs to be done about it, you could say, well, okay, let's agree to each other here that if you don't clean this up or if you don't fix this, it's going to cost you $1,000. In my opinion, I always recommend to a client not to do a holdback. I don't like holdbacks. And the reason why I don't like holdbacks is because let's say something's broken, floor is broken, or there's like a dent in the wall or something like that. They have to go and call their own contractor. Now the seller has to call their own contractor. I don't agree to holdbacks because when I'm representing the buyer, it doesn't make any sense. When I'm representing a seller, sure, because now it's their money that you're like holding back, right? They want the cheapest route to get to this solution, right? Whereas the buyers don't want the cheapest route to get the solution. They just want to get the thing done, whatever it is, and they want it done properly. And they don't care how much it's going to cost the person to do it. So when I'm acting for a buyer, I always recommend a credit, not a holdback. And the reason for that is you have to rely on the seller after closing to call a contractor. That could happen the next day, it could happen a month from now, like nobody knows. You're at their mercy to call the contractor to come out and do it. You then get a contractor. They're going to get the cheapest contractor that's just going to go and like slap some plaster on the wall and sand it and maybe not even paint it with the same color, but it's done, it's completed, right? Then you're arguing, is it completed or is it not completed? And then there's like more legal fees because we charge $500 an hour for arguments. So it ends up costing more money to the buyer ultimately, because I'm charging the buyer that $500 for this negotiation at this point, right? Contractor then goes and damages something else in the home. You can't sue as a buyer the contractor because you're not the one that hired him. You have no privity of contract. You got to go after the seller, and the seller, what are they going to do? You're not going to go after the seller for it. So I find when you're acting for a buyer, it's easier to just figure out how much is it going to cost us to fix this, and then just get a credit and do it yourself. You're in control of the contractor, when they're going to happen, how much you're going to spend it, and you can even upgrade it. You can spend the extra money to then bet nicer floors if the floors are scratched, right? Or a nicer fridge because the fridge is old and smells or whatever, and it's dirty, and it's just easier to go and buy a nice new fridge at that moment, right? So I always recommend to buyers, just find out how much it's going to cost you. Even if it costs you more money, let's just get a credit and like let's move on.
So when does the credit kicks in? Like
On the day of
before
closing. On the day of closing. We usually do it between lawyers. It's
Ah.
adjusted on the final statement of adjustments.
Okay.
And for buyers, I always recommend credits. For sellers, I always recommend holdbacks. And it just becomes down to like negotiation of what someone wants to do. Like some sellers just don't want to be bothered with it. They're not going to go and worry about hiring contractors and figuring out who they're going to hire and what they're going to do. They're like, you know what, just give them $1,000 and just like let's just move on. Right? Some people are like that. And others are no principle. I'm going to fight this to the death, and like it's going to charge me $500 an hour and whatever. So usually when we tell them it's going to cost them $500 an hour and it's like $1,000 issue, they're like, let's just give them $1,000 credit. So those are the battling points on the day of closing that I find usually that are happening lately a lot. And then there's the no mortgages. That's the really big issue this past 2 months, July and August. I don't know what it is. People have not been able to get their mortgages. I had three or four deals that have completely fallen apart because the lenders walked away from the deal last minute. Literally on the day of closing, one of them happened where the lender walked away from the deal. And these are like B lenders. These aren't, they're not going to TD or these are like community trust, home trust type of equitable bank type lenders. Where, and I don't know what it is. Did they not review the file in advance? Like, I'm not quite sure what happened on that side of things.
Well, they do.
We don't get to hear the reasons.
No, they do 2 credit checks.
I have no idea. I have no idea what's going on the deal. One of them, I think the guy said that they wanted more documents from me, and I was like, okay, well, what kind of documents? And he didn't really answer. So, and then next thing you know, I got a cancellation notice from the lender. I'm canceling this deal. So we're finding that a lot, and that creates a lot of headaches for the buyers now, because now they have no home. They got to pay extension fees to the sellers. I mean, I've had one extension that's been going on for a month and a half. It just died on Friday. I don't know if we're going to revive it today. We'll see what happens, but. Same thing, lender walked away from the deal. They are getting a new lender on board now with the new lender's new closing dates like September the 19th. Sellers like, well, I can't, we've been going on since like beginning of July with these extensions. So we'll see what happens. But like mortgage issues are a big problem at the moment. So, prior to getting into a deal with a client, I always recommend make sure that they're pre-approved properly. It's not just about, we got pre-approved, but I don't know how you guys are going to do it, but just making sure they're well qualified for their deals. I find finding out what they do for a living is helpful. If a person's self-employed, expect some issues on the financing. Those are the ones that are tougher these days. If it's someone that's got a good job, they're working for like Google or something like that, probably not going to have issues, but you never know. People have bad credits, they have to pay off like credit cards, like we've been paying off crazy amount of credit cards and line of credits for people, unsecured line of credits and stuff like that. Leases, we got to pay a lot of leases out for a lot of people's cars. Lenders are forcing lease payments to be paid out completely. So mortgage issues are quite a big problem. Our biggest problem this month, last month, has been so July and August has been mortgages.
Is it primarily on the condo side, or is it detached?
Doesn't matter.
Doesn't matter.
It doesn't matter. No. In fact, we're not even seeing a lot of condos.
Right.
That's even worse.
Even though the profits are at the best ever.
Yeah, I mean, my entire practice many years ago was new builds, and then it switched to condos, and now it's like freeholds. Like I don't even see a lot of condos. I can't remember. I think I did 2 status certificates last week, and I was like, oh wow, status certificate. Haven't done one of those in a while. So
I understand that the problem is now what you have it's about the buyer. Yes, like they want another file or something. They don't believe that the income is okay, whatever the case may be, but it's about the buyer, not about the property.
Not about the property itself, not necessarily. No, sorry. Sometimes it's about the property. I had one of the deals, the appraisal came $110,000 below the purchase price. So the client had to go and figure out how to get an extra $110,000 down payment.
The appraisal goes lower.
The appraisal came down $110,000 lower.
Yeah.
Yeah.
Scary.
I think it was like $1.2 million, the home. Came 110, I don't know where it was. I don't think it was in Toronto.
Oh, wow.
I think it was somewhere outside of Toronto, like the GTA somewhere. But we're seeing those as well. It's not just on the like one-offs. It's quite a few of them where we've had appraisal issues. So I don't know how they got to that point. Like I don't know how you get to a house buying for $110,000.
Well, it's just gone down, right?
Yeah.
It's gone down really quickly.
Yeah.
See, it was
But that quickly, like in a month?
Yes.
Yeah.
You haven't seen anything yet.
Yeah.
Yeah.
So is there any good advice for us? Because like we obviously try to qualify our buyers that we don't waste
That's
time.
my advice was
But-
just look at the client, right? Like I said, if the client's self-employed, the chances are they're going to have a harder time getting a mortgage.
Yeah, like we all of us, yeah.
Yeah, no, I'm just saying the banks are having a harder time with people that are self-employed. I find.
That's always been.
Yeah, it's always been the case, but I think it's a little bit more now because pricing, businesses might not survive and this and that, and so I guess maybe they're just looking at it a little bit more in depth than they used to, perhaps because they knew values were going up. I just did a deal the other day where we did a sale and it was underwater by like $80,000, and the lender agreed to just cut their losses and close the deal. We're seeing a lot of those too on the sale side where they're underwater, which is terrible for you because you're going into the deal. You should be figuring out how much of a loan this person has before you get into the deal because your commissions aren't getting paid. We didn't pay the commissions on that guy. We said, sorry, there's not enough money to pay the commissions. We don't even have money to pay the mortgage. So, you don't want to waste your time selling a home and then not get paid on it. So one of the easy ways to figure out what kind of loans this person has in their home is going on to onland.ca. I don't know if anyone heard of this. onland.ca. It's the government website for the Land Registry Office, and it's real-time live data on what mortgages the person has on their home. Better than GeoWarehouse. GeoWarehouse, I find, is a little delayed and may not always be up to date properly.
What was that website?
onland.ca.
Okay,
Yeah, you have to
You
pay.
gotta buy the report.
You have to buy the report. It's like $35 or something like that.
okay.
You can buy it on your Visa. But yeah, it gives you an idea. Okay, I've got 3 private mortgages. Oh shit, like that's probably going to be a problem. You know, and you look at how much are those private mortgages registered for. If each one's registered for, let's just say $500,000, and you got $1.5 million in mortgage, and you're selling a home for $2 million, maybe. But then on top of those mortgages, there are usually fees, back payments that they haven't paid, interest that's accumulated, penalties that are like in the tens of thousands of dollars typically. So now you're getting really close to the $2 million mark, right? Will there be commission to pay? You know, what's on 2 million? I don't even know what it is, 60,000 roughly? You know, like, is there enough commission to pay that afterwards? So I always recommend that. Before you list the home, look at the mortgages. Even ask them, just be like, what is your balance on your mortgage? Send me some screenshots. I want to see what's left over. You know?
But you're saying if they have fees accumulated, you don't even know about those.
No, you don't. But you can estimate it. You can kind of make some rough math on figuring it out. You know, if you're selling a home for $2 million and you got $1 million in mortgages, there's no way there's going to be $1 million in fees. So there's numbers there that make sense, right? But if you got a $2 million home and there's a private mortgage for 1.5, maybe not. Most likely it's fine, but you know.
Did the law firm get paid?
Yeah, the law firm always gets paid. Yeah. We hold the money. Yeah, we hold the money, so we get paid. Yeah.
So you've heard about this Brampton lawyer, is there was what 10 million or something like he?
Yeah.
I don't know how this can happen. I don't even.
Like anybody can touch the trust.
Yeah, but I mean, if there was a closing, like you expect the money going into it. I don't know because it was some kind of transaction.
There's a lot of them now. It's not just that. It happens at least 2-3 times a year now.
Yeah.
They're like creating a bad name for us, just like Hyper. No, I mean we you know that's why you got to go to a lawyer that's reputable at the end of the day. You know, you don't go to like a guy that's working out of his basement. It's just weird. You know, it's not trustworthy in my opinion. Okay, so common issues, clause 10. So these are common issues that come up a lot. It's from clause 10 in the agreement. I think it's clause 11 in condos agreements, clause 10 in freehold. Or was it 9? One up or one down, I can't remember. So common closing issues that you can't do anything about because you've agreed to accept them as a buyer are things like registered restrictions, charges, liens, and encumbrances, they would be removed from title. So those have to get removed from title either way, one way or another. But I find what happens sometimes on closing, and there's nothing you can do about this because you want it removed from title, so you have to like make sure you work towards getting it removed, is liens and encumbrances. So liens, these are things like CRA liens. Could be condo liens on a condo. We had to deal with one the other day. It was like $12,000 in condo arrears. Depending on who's doing it, they either know how to discharge a lien or they don't. And we as lawyers need the lien registered on the day of closing, or we need some sort of assurances that it's going to happen. And it depends on who it is. So if it's the CRA, we'll accept the lawyer's undertaking to deal with it, but we want to know what the actual balances are. So we need like some sort of statement from the CRA confirming it, that they understand that that loan is referencing that specific interest. So what would happen on one of our deals is we had 2 CRA liens on a seller's home, but the payout statement that the lawyer gave us was only for one of them because it only referenced in the payout statement one of the instrument numbers. There was 2 instrument CRA liens registered. It turned out that there was 2 different divisions at the CRA that were dealing with each one separately. And the lawyer didn't realize this. They're like, oh yeah, we got the payout statement, we're going to discharge the liens, everything's going to be good. And I'm like, no. Where in your payout statement from CRA does it say the second one's going to get paid out? And they're like, it's right there. And I'm like, no, it's not there. You know, and we ended up arguing, and we couldn't close the deal on time. We had to extend the deal by a month and a half like it kept going, but it was a month and a half, but it kept going every like 2 weeks. We kept extending because they weren't getting the proper answer from the CRA. And the CRA was the one that caused this problem, essentially. But I, as a buyer's lawyer, can't close this deal because I also have to represent the buyer, but I'm also representing the lender on their deal, and I have to make sure that they're in first priority. And there's this new case law about a few years ago that created super priority liens on CRA liens, which take priority to everything on title. It doesn't matter who it is. They just get their money immediately. So, you know, we can't close the deal, so we got to extend the deal potentially. So buyer now has to go into like an Airbnb or whatever, family and friends for like another month to potentially deal with it another week or two. So that has to get done. There's nothing we can do else about it. It has to get removed from title to lien, right? And that's just an example of how we ended up having to extend the deal. And it sucked for the buyer because they didn't get their home on the day that they were expecting. It was a terrible situation because they had 3 young kids. And they had given up their lease on their property and they had to go to like an Airbnb for a month, basically. The other ones that there's nothing you can do about, which is literally nothing you can do about, they run with the land. And it says it in the agreement, is A, B, and C. Those are things like municipal agreements, drainage sewer agreements. These are in subdivisions typically. So we had a guy who was buying a home that wanted to redevelop it. Never told anybody this. Didn't tell the agent, didn't tell us, didn't tell anybody that they were going to plan on redeveloping this land. We told them that there's an easement. It's covering 20 feet width from front to back of the lot. So you know in Etobicoke there's those properties that have the garages in the backyard on the side. For whatever reason, this specific one was behind the power lines. And his house, of all the houses in the neighborhood, had the easement where the electricity company can drive through it, through the backyard, into the backyard to go and fix the power lines. And so he couldn't develop because that can't be developed on, right? And we had to basically negotiate to cancel the deal, to get him out of the deal because, and there's again case law that allows us to do this, to basically get off the deal and say that this for the purposes. And they tried to argue that, well, you never kind of explained to us that was your purpose and you should have done your own due diligence and all that sort of stuff. So I think it's still going on. I think it actually went into litigation. I don't know what happened to it yet, but you know, it's kind of important, you know, when you're dealing with the builder client, or if they have intentions of redeveloping home, like, I don't know if I'm going to do it or not, you know, just kind of like let us know. We can do a title search to see if there's any easements that affect the property from preventing them from being able to build, because typically some easements will prevent you from building on top of them. Yeah.
Who paid for the Airbnb costs of that with that buyer? That's in the previous scenario you gave.
We couldn't get it from the seller. Typically the seller should be paying for it. We should be negotiating to get it paid by the seller, but the seller was TD. It was under power of sale. And TD was doing the power of sale on their own. They didn't hire a lawyer. Was it TD? I think it was TD. And the lawyers at TD don't clearly do real estate and didn't realize. Or they were just playing stupid and thought that they can get away with it or something like that. I don't know. Because they knew that they were losing, right?
But typically, if it were TD, if it were a seller,
we would try and negotiate to get the seller to pay for it. Yeah. I mean, I have a deal at the moment that didn't close because we have a tenant. And I probably should put this one up because that's happening a lot lately as well. Actually, it is. It's the bottom leases. Selling a property with a tenant in it and having some sort of clause. What is it? The N12, where the buyer is going to move into the property and they give you an affidavit. We're going to move in. You got to get out. And you give them the 60-day notice, you close on the 90th day just to make sure that they're like moved out. They never move out. They never move out. It doesn't matter that you've done it properly. They're always still there. And they know that they can't get kicked out. It never works out. It never works out. And this deal, this family, they bought a triplex. The parents were going to move into the one unit. The 2 brothers with their family and children were going to move into the other 2 units. It was a great plan. They had to get rid of all the 3 tenants in the building. 2 of them left, 1 of them didn't. And the deal didn't close because they're like, well, I don't want to deal with it. Now I got to deal with this tenant to evict him out of this property, right? So the deal didn't close. We're still negotiating with it. Actually, it just happened like last month. See what happens, but like they never close. Just don't even bother. Or if it's a really good deal, that's fine. Just set the client's expectation that this may drag on forever. You know, are you okay with that? Are you okay with not getting this unit if it takes another 4 months to get these people out of here? There's this concept that paralegals use. It's called cash for keys, where they give them like 20 grand or whatever, and like I get the keys, you get the 20 grand, and we'll get you out. That's not working lately either with tenants.
Really?
Yeah, like I don't know what it is.
They want more and more.
Yeah, it's.
Well,
You know, and
I think
with
that
rents the
is-
way they're dropping now, you would think that they would just take the cash and leave, but they don't. So, I don't
That's
know.
how long they've been there too.
Yeah,
Yeah.
if they've been there for like 10 years, their rent is so cheap.
Yeah.
They
Yeah.
can't get the same thing.
So I find those cause a lot of problems. You know, always look for units that are completely vacant if that's the case, or work with sellers that have already kicked out their tenants and then list it. Listing a property with a tenant and hoping that they leave is not. There's no hope there. Okay, so serious ones. So work orders, deficiency notices. These are big ones. These are actually so with this, you know. I like this clause, but I don't like this clause. Everyone uses this clause. I've seen a lot of agents, they put this in their standard Schedule A clause. This there's no work orders. Seller represents there's no work orders on the property. This clause causes a lot of problems. So there's a thing called title insurance. Everyone knows what title insurance is. Title insurance typically allows a buyer's lawyer to avoid having to. Yeah.
You can't get title insurance anymore. They're running out of money.
Oh, what a news.
I don't know. I've never heard of that.
Yeah.
But who's still ordering it today? I don't know. Hopefully that doesn't happen because it's very expensive to do a deal without title insurance. We charge about $5,000 to $10,000 to do a deal
Yeah.
without title insurance.
Without,
Title insurance.
You charge?
Yeah.
Why?
Because we have to do a lot of searches. And so this is the thing. Title insurance avoids having to do a lot of off-title searches. So these are searches. This is where this clause comes in, right? So off-title searches are things that are not on title. So these are things that the municipality has a record of. So you've got building and zoning issues. So was there a building permit that's still existing on the property that's open? Is there a zoning violation? They got charged X amount of money. Is there a bylaw, they didn't cut their grass for the past 3 years and they kept getting charged every year and there's like $3,000 of like bills outstanding on the property. We don't have to do any of those municipal record searches because title insurance steps in and covers them for the buyer after the closing. So buyer moves in, this happens all the time. Buyer moves in, wants to like build a new deck. They don't like the old deck. They want to tear it down, build a new deck. You need a building permit for that. And then they realize that there's already an existing permit outstanding for something else in the home, and the city won't allow them to issue the new building permit because the previous one still has to get closed in order to get the new one. So they can't build their deck because the previous issue is still outstanding. Maybe it costs them X amount of money to close that permit, and then they can go and build their deck. So whatever it costs them to close that permit, title insurance steps in and covers that cost. When you have this clause in the agreement, title insurance says, well, no, because someone should have gone and done a search with the city to confirm that there are actually no work permits that the seller represented. There's no work permits. If this clause doesn't exist in the agreement, title insurance will provide that coverage. If this clause, because they ask us for a copy of the agreements when we file the claims. If this clause exists, they say, no, we're not going to give you the coverage because someone should have gone out and there's a positive duty on the lawyer and the client to actually physically go out and do the search and make sure that there's no actual permits outstanding or work orders and stuff like that. So I always say, if you know nothing about the property, don't put this clause in because title insurance will step in and deal with it. If you know that you're buying a home that's been built, newly built home by someone, advertised as newly built, new renovation, $500,000 in like renovation costs spent on this home. Yeah, chances are they probably did something to this property that required a building permit, right? Maybe knocked some walls down, maybe like extended the backyard, maybe they topped it up. I don't know, whatever the case is, right? In that case, this is important because you want to make sure that prior to closing, there are no building permits outstanding because you're not going to get title insurance at that point. Even title insurance will say, well, you knew the listing said that it was like a brand new home. Why didn't you go and do the search for it, right? They'll find a way to get out of it because they're insurance companies at the end. They're not going to like cover everything. So it really depends on the property, right? And what information you know about the property.
So if you're a seller agent in this scenario, would you ask, and they did an addition on their home where they tore down the house and rebuilt it, would you ask for proof of the permits being closed?
Yeah, you can. You can say, hey, did you guys get any permits? And they're like, no, we didn't get any permits. Okay, cool, great. Yeah.
That's a problem.
That's a huge
Well, no,
problem.
but like, I mean, you know, not your problem. It's their problem at that point. And then you're like, hey, we got permits. We closed them. Are you sure you closed them? Did you guys talk to the city about this? Do you have anything from the city that says that they're closed? Because if the buyer's lawyer goes off and does a search, they might discover that, and that creates a problem on closing. And especially if you see a clause like this, where you're telling the seller, hey, you're representing there are no work orders or permits outstanding, make sure there are no work orders or permits outstanding, right? Like as a listing agent, you want to, I hope that you guys are doing this because you should be doing this, but when you get an offer in as a listing agent, you should be sitting down with the client and reading through the clauses and saying to the clause, this is what this clause means. Clients don't know that. You got to do that. That's kind of your responsibility as a listing agent to sit down with the client and say, this clause means this clause means this clause means this. Are you guys good with it? Can you make this representation, right? I get tons of deals where sellers are like, no one told me about this. I didn't know I was agreeing to this. I'm like, well,
Do you know what?
not a conversation for me to be had with you.
In fairness too, not that, and of course biased a little bit, but there are sellers that don't want to spend the time and sit with you and go through each clause for us to explain it. I've been in situations with sellers, they're like, this is
But get that in
taking too
writing
long.
But get that in writing from them. Say, hey, look, it's my responsibility to have a chat with you about this clause. If you don't want to have that conversation with me, that's fine. But please confirm with me that in writing that you don't want to have that conversation. Because that'll
This is
protect
happening
you.
during the process, they're like, oh, this is taking too long, let's just
I know.
go through it faster. I
But
can't
that's-
get that in writing at that time, it's not practical, in theory it is.
Yeah. But that's the risk you're taking, right?
But so what would be in writing? Like, not
Just
like,
an email.
I didn't have a conversation, but
Just an email. Just an email. Because
Sorry?
the complaints come back to you not necessarily in a civil action court where someone comes and sues you, but somewhere in RICO where someone complains about you, right? So, I mean, it could lead to a civil litigation where you get sued,
Yeah.
and you have insurance for that typically. But usually the issue is more of a complaint against you with RICO, right? And that's what you want to try and avoid is dealing with RICO as much as you can.
So if I know a basement washroom was added where there was never a basement washroom and I'm working for the buyer, should I put in this clause, making sure that they had a permit to build that washroom in the basement?
That's a different clause, though, right? Seller represents that they obtained a permit to build a washroom.
Right, that clause, yeah.
And then represents that no work orders or permits are outstanding, and then we can go and do a search to confirm if there are any outstanding. When I see this
Because I normally
clause,
put the permit clause in, but I don't put too much more beyond
yeah,
that.
when I see this clause, I tell my team immediately request the search from the city. A lot of lawyers don't do that because a lot of lawyers don't realize what title insurance covers and what title insurance doesn't cover. They just think title insurance is this great thing that covers everything. It doesn't. It doesn't cover everything. We have a lot of deals where people file claims and they're like, nope, we're not covering that because it falls under this random exception 28C. And you're like, what the hell's 28C? And then you go and read it and you're like, oh shit, yeah, actually this doesn't cover this. So this comes from experience too, right? We've been burned on things and we learn from it. And now we see this clause, we immediately go. 90% of the time when I see this clause, I don't need to do it because it's not a brand new home. It's not something that was renovated or it was just like a random condo. The worst letters to read on these type of things is from a condo because there's like 1,000,001 outstanding building permits in a condo and you got to figure out which one's your unit. So yeah, try and avoid it, but not necessarily avoid it because it might be needed in one of your deals specifically, right? So it's not necessarily a bad clause, it just creates a lot of problems sometimes. Because what happens too is, let's say it was not a renovated home, or the people that owned it didn't renovate, it was the people prior to them that did the renovation, right? And you as the buyer now, go and do the search, find out that there are open building permits, they didn't know. They're like, we didn't know. We didn't do anything here. We didn't do the renovations. The option at that point is, okay, well, let's extend the deal for you to deal with the city to figure out what needs to be done, file your title insurance claim. And the alternative is if there's enough time, title insurance typically will step in and provide some sort of coverage to the new buyer. But it could delay closing by a few days because that process does take some time. It doesn't happen like in seconds. Like title insurance claims could take a week to 2 weeks before they even answer you. So, you know, that could delay closing as well. You'll get coverage and there'll be an issue where, you know, it'll be not the buyer's problem anymore, but it could delay the closing a little bit. And that creates some stress to the buyers. I'm not saying that, like all of my examples doesn't necessarily mean the deal doesn't close. Usually the deal's closed, but there's usually some sort of delay and costs associated with an angry client because now they're got to go to an Airbnb for 2 weeks or whatever it is, right? Okay, so then there's no insurance. That's happened to us a few times where people aren't able to get insurance on the home for whatever reason. Just insurance companies are just not willing to give insurance on a specific home. Very rare, but it has happened in the past. Or it just takes them too long to get the insurance. They forget about it, and you know they're scrambling on the day of closing trying. We follow up with them, but like they just don't get the insurance on time. You can't close a deal if there's no insurance on a home. If there's a mortgage, I can't close the deal. If there's no mortgage and they're paying cash, I don't really care about the insurance. I only care about when there's a mortgage. Leases we talked about. Okay, so remedy. There is a remedy to all of this in the one. Oh, sorry, how do I go back? So there's a remedy to this serious stuff, which is the work orders, the building permits, all that stuff. Building permits, outstanding work orders, that sort of stuff. So the remedy is in the agreement, actually, in paragraph 8. And the remedy essentially is termination of the agreement unilaterally by the buyer. So, and the only way that works is if the seller says, well, I'm not going to close the building permits, I'm not going to deal with this title issue. It might be something on title that they refuse to like remove from title, like a lien or a mortgage or whatever. The seller, so unwilling to remove remedy, blah, 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 get title insurance, because sometimes you can get title insurance over the issue, and we can close at that point too if there's a building permit situation, right? And then basically the bottom part here is basically it's that the agreement becomes terminated. So the seller can either say, well, if you're not willing to remove this issue or deal with the title issue, then I'm terminating the agreement, I get my deposits back. It's written in the agreement. That's the remedy. So not the greatest remedy because you don't get the deal, right? Deal doesn't close. So the buyer unilaterally was able to terminate the agreement. Well, it's a good remedy for buyer. It's not a great remedy for you necessarily. But yeah, so that's essentially the remedy, and we use this all the time. So if there's a building permit that's outstanding against the property, we can't close the deal because we also represent the lender, and it's a root of title issue. And we have to make sure that building permit gets closed before closing. So again, do we need to even search to find out if there's building permits? And if the answer is no to that, then we rely on title insurance to cover it after closing. So at least we can get the deal closed, and title insurance steps in later.
We've been led to believe, like, sort of, I think in our industry, that title insurance is the end all to be all.
No.
But every time it's not.
No. In fact, when we get audited from the Law Society, they go down this path with us, and we're like, well, where's your discussion with the client about this title issue that they understand title insurance is not covering it? I don't know how many law firms out there don't even meet with their clients to explain documents to them or explain title to them. We actually send them a title report. I send them a summary of like, hey, we did your title search, and this is X, Y, Z on your property. You've got this easement, you got that easement. The builder can go in for the next 10 years. There's a sewer easement here, and there's also, by the way, this mutual right of way between you and the neighbor. FYI, just so that they know what the property.
And this is prior to closing?
Prior to closing on the title search date. Prior to this title search date, yeah. We have a schedule in our office where 1 to 2 weeks prior to title search date, we actually do the title search. And then after the title search, we actually send a report to the client, like an email that says these are the things that are of issue. Like, I'm not going to tell them everything that's on title. I'm just the easements, rights of ways. That's what they want to know usually.
That's a great idea.
And go down the discussion. Sometimes it leads to a really bad discussion because they're like, oh shit, I didn't want this. I don't want this kind of thing. And you got to tell them, well, okay, well, I can't get you out of the deal because of it. This is not something that I can get you out of the deal with. Or maybe it is because, you want to develop and you've told everyone you want to develop and it was like conditional on inspections and you did this and that and there's a way to get you out of it because of that. But yeah, so that's what we do on our end at least.
Is a survey is a help for you or not? Like a survey.
No.
Like, say, well, yeah.
Survey will only help in very limited circumstances. For the most part, we don't need surveys. Title insurance actually covers for minor encroachments. They don't cover for major encroachments. Survey was actually, we had another deal where we were buying a home, Owen Sound, I think it was somewhere in Owen Sound, and there was an issue with the legal description where they didn't own part of the lot. So there's two parts to the lot, part 1 and part 2. I don't know if you've ever seen that looking on our plan. And the part 2 was this little thin strip, and it turned out that their home was encroaching onto part 2, but they didn't own that part 2. Part 2 was owned by a school. And at some point in the registry system, the old way, some lawyer missed the description to include both parts. And when it got converted to the new system, the land titles system, they basically said, yeah, it's only part 1. And so there's this encroachment. We ended up getting title insurance to cover over encroachment issues on that specific property, so that if, for example, someone, i.e. the school, came back and were like, hey, we want our part 1 because we want to build a tennis court, and we need that 1 foot strip here. They could tell them to tear down that part of the home, rebuild it so that they can access that land because it's their land. And there's like adverse possession claims that you could probably make and that sort of, it's very difficult. So we got title insurance coverage over it. So they've had something to do, and the title insurance company right now is actually hiring a lawyer to deal with the city to sever that land and give it to the homeowner. We'll see what happens with that, but we managed to get it closed. But it's a discussion with the client that we had in advance of the closing date, prior to the title search. After we completed our title search, we sent it to them. We're like, hey, this is an issue. What do you want to do here? Like, we can either ask for some money back and you just deal with it yourself. We can try and force them to like not close and force them to deal with it after closing. We can extend the deal, and we did both of those options. And I think we settled on the fact that they were actually the ones that were able to get title insurance, and they gave the title insurance coverage to our client. And the client was happy with that. And the coverage from title insurance wasn't 100%. There was a risk, and the risk was that if a new buyer came around and said, hey, I'm not happy with this issue, I'm not closing this deal, they could technically do that because the title insurance doesn't cover to fix the issue, it only covers to deal with the issue if it arose in the future. So if at any point the school came to say to them, hey, you need to fix this, title insurance would step in and deal with it. But title insurance wouldn't take the steps to actually fix it. Like, someone has to tell them, someone has to sue you in order for title insurance to step in to deal with it. That was the coverage that they would get.
So who's getting the title insurance? The seller?
The buyer.
The buyer.
So the seller
Right.
got the title insurance and gave it to our client. They managed to convince the title insurance company that the buyer needs this title insurance coverage because we made a mistake or whatever the case is.
So the seller, though, owns the policy.
No. The buyer owns the policy, but they were the ones that actually went out and got it.
Okay.
So if I went out to get it as
That's
a buyer's
all.
lawyer, I wouldn't be able to
Yeah,
get
that
it.
is odd.
They filed a claim under their existing title insurance
Right.
coverage, basically.
So who should have it? The buyer should?
Buyer always has
Buyer.
title insurance.
The
Yeah.
buyer.
And then as an owner, you continue to hold it until you own the home. When you sell the home, that policy basically dies. So if something comes up during the ownership of your property, the title insurance steps in and deals with it. So it's very limited, like, circumstances sometimes where you can get these weird coverages. But sometimes we help deals close that way. We can kind of explain to the title insurance company, this is the issue, this is how it's going to affect you, because we have to give them an opinion as well on what the issue is, and then they decide on their own whether they're going to give the coverage or not. But yeah, very, very rare examples I'm giving you guys. These are not things that happen every day. These are just like,
Are the fees going up for title insurance or not?
fees have gone up this year for title insurance substantially. I mean, I have repeat clients that are constantly being like, wait, I don't remember paying that much for title insurance. I was like, yeah. Everything's going up, inflation, I guess, I don't know. It's the claims, right? It's all about the claims that they have. There's a lot of fraud claims the past few years, so they've had to deal with that. Okay, so common problems that I find a lot, these are more of like minor things, and I find these are the things that actually affect your commissions a lot as well. Fixtures and chattels, what's the difference between a fixture and a chattel? They're arguing over whether it's a chattel or if it's a fixture and should be included or not included in the agreement. I always like to give the example, imagine the house is a dollhouse, like kid's dollhouse basically, right? And you flip it upside down and you shake it and everything that falls off
Is it chattel?
is a chattel. And anything that stays is a fixture, right? That's a great analogy kind of when you're explaining it to a client, right? So just kind of look at it that way because sometimes someone's going to be like, hey, that's a fixture and it should have stayed with the home. And it's like, no, it's a chattel. It's like a mirror that's hung on a nail. It's no different than a painting, right? I can take that mirror. If it's a mirror that's glued to the wall, that's a fixture. Don't take it out because you're going to leave holes behind it. Anything that you have to take out where it leaves a hole behind it, you got to fix it, and you have to make sure that it's included in the section where it says fixtures excluded in the agreement. So that usually causes an issue a lot with people where they think that they're buying something that's going to come with a home, and then they find out it's gone, and they're like, where did it go? And like cabinets, loose cabinets, like people buy these IKEA bookshelves and they put them in basements. Those got to go unless they're like attached to the wall. They got to go. They're not built-in cabinets. They're just cabinets that you put there yourself.
So if they fix it with the one screw is already the fixture, yes? Like they don't want to take it out, just to put the one screw.
Not necessarily. Like if it's like if you're securing the cabinet to the wall because you don't want it to fall because you don't want your kids to like break their necks.
Yeah.
That's still a chattel. Because you just take the two screws out. And
What about the TV
okay.
stands? Because they
TV
oftentimes take
stands?
them.
So TV stands are a good one. TV stands are considered fixtures. The TVs are chattels. The chattel goes, the stand stays. Unless you exclude it from the agreement, then you can take it. But then you also have to fix the wall after you take it out. Yeah, that one's actually a good one.
The secret is if in doubt, just throw it into the agreement.
Yeah.
Throw it all in the agreement.
Throw it whatever you can. Yeah. I also find too a good one with chattels, and these are appliances, is don't just put fridge, freezer. Like, what is it? Is it a Bosch fridge freezer? Is it a you can go as far as putting a serial number on it if you want to, because like you put a Bosch fridge that's stainless steel, and the seller absolutely hates these buyers because they're like nitpicking at everything. Well, technically, the guy could just take that fridge out, the Bosch one, and put a white one in, because it's still a Bosch white fridge, So like you can say existing stainless fridge, and then you got photos of a listing that show the existing stainless fridge that was there. So you got a little bit more detail about it. Don't just put fridge or dishwasher or like washing machine. Because you might think it's a deal that's friendly, and then it turns very unfriendly very quickly.
Oh, yeah.
Okay, so rental items, I find a lot of commissions have disappeared because of this, where you're not asking your clients what kind of rental items they have, get in writing, maybe get some sort of listing questionnaire. I think Oria's got a form, like a listing information form that you ask your clients to fill in. Make sure you go through that with them and make sure that any rental items are marked off. Some people don't even know that they even have rental items, to be honest, because it's not like their fault really, but like they've been paying $35 to Enbridge on their hot water tank. Yeah, because Enbridge bills the hot water tanks, and they don't even know that they're even paying
They've
for.
separated it now, though.
Sorry?
They've separated it now.
Have they?
Yeah.
It's
Enercare, yeah.
No, Enbridge. Enbridge.
I know, there's Enbridge and then there's Enercare.
Enercare,
They've
yeah.
separated them.
So Enbridge doesn't bill them anymore?
No.
I think they do still.
Or lucky not
Honestly.
for mine. They
A lot of
separated.
people have no idea.
Yeah. So anyway, just make sure you have those, because what happens is on the day of closing there could be like a notice of assignment of rents registered, or notice of security interest registered on title that we ended up having to get removed from title, so we got to request a payout statement. Turns out the water tank is like $3,000 to pay out, and they're like, oh man, I didn't know that, and then they start pointing fingers at the realtor for some reason. So
Now, are those easy to remove, those nosy, because they became
so the
illegal,
nosy
right?
we removed from title, but now they've got the issue of they actually a contract that they're going to potentially get sued over if they don't pay out that contract. So like we as lawyers are allowed to remove the noses on title. That's easy. But the contract still exists, right? And that contract now is a consumer contract between a company and a consumer, and they could potentially affect the payout of it because they can sue you for not paying it out or not paying and not getting assumed. Like the buyer's not going to assume it because they never agreed to assume it. So you as an owner still have to pay this contract. So either you continue paying your monthly payments or you just pay out the contract. Most people just pay out the contract, right? So it costs the money, and then they usually ask the realtor, "Why didn't you ask me about this rental contract? Why was it in the agreement? I didn't notice it was in the agreement." Back to my point of making sit down and read the clauses with the clients, right? Furnaces, air conditioning units,
Security.
those are all typical things that we see as rental contracts. Furnace, AC, hot water tank,
Water softeners.
water filtration systems. Those are the main ones. And then what if someone else doesn't close? Well, that happens. Just people change of heart or whatever. I've had one deal where actually we have to get the deposits back. The main thing there is that you're going to litigation at that point, and it's unfortunate. I don't know why people do it. It doesn't happen often, but it sometimes happens. Problems after closing now. So these are all things that happen before closing. Things that happen, I find, after closing are broom swept condition, good working order clause, right? We already know about that. Garbage is left behind. We charge $500 an hour to deal with people in negotiating of removing garbage. So most people just go and remove the garbage on their own, but happens a lot. Buyer beware happens a lot, where they come after closing. They're like, "Hey, something was broken. Like it wasn't working." It goes back to our conversation. Like, well, what kind of clauses are in the agreement? Is it supposed to be working? Is it even related to a chattel? It could be something else, right? It could be scratched floors. Were they scratched prior to? Do we even have photos? Did you even look to see if that hole was there? Because the seller's claiming that it was there, but maybe you didn't actually notice that it was there. It was always there, right? That's usually the argument from the sellers. It was always like that.
Yeah, well, when the furniture's in it, you can't see everything, right?
Yeah,
Until
fair.
you get a look, you
But those
see
are
it.
patent defects then.
Yeah.
So patent defects are things that you are expected to assume there's something underneath the bed, for example. Behind paintings, there's going to be a hole because the nail or the screw. Those are expected. You can't ask the seller to fix those things. But if it's in plain sight and you saw it, let's say you didn't do a home inspection and there was leaking in a corner somewhere, and then you discover there's a big leak after closing, well, property was always like that. You should have looked into it. That's buyer beware, right? Latent defects we talked about. Suing. Basically, you sue for whatever it is you threaten with lawsuits. That's your resolution. There's nothing else we can do. There's no magic clause, or unless someone negotiates a credit of some sort or a holdback, the next step after that is just suing each other. And do you want to do that? So if it's something that's going to cost you $5,000 to fix on your own, I mean, sure, you can go to small claims court on your own and sue if you want to, but it's probably a waste of your time. And then our fees, I mean, not like we don't do litigation, but if you go to a litigation lawyer, their retainers start at $10,000 and they go up from there. So I always recommend when people are thinking about suing anybody, it's really got to be worth it. There's got to be a lot of money there to sue someone. So if something costs you like $50,000 to fix or $100,000 to fix, yeah, probably not a bad idea if it's in your right to sue, if you're going to potentially win that case. But you don't want to go to court where it's like a 50-50 chance, or like potentially you're not going to win because you don't have the right evidence or you don't have the right situation. Well, you're just wasting money, right? So it really depends. You got to really talk to a litigation lawyer. We're not litigators, but you got to really talk to a litigation lawyer to decide if that's something that you're going to do. Unpaid taxes or utilities happens all the time. I don't know what's wrong with people. Like, why are they not paying their taxes? But I don't know. Every third deal, I feel like I'm getting an email after closing where the seller hasn't paid their property taxes. We don't, as buyers, we don't search the city to confirm if property taxes are up to date. We rely on the information they give us because title insurance covers it. So this is one of those issues where title insurance will step in and deal with the unpaid property taxes after closing. So they're covered one way or another. Buyer's covered. It's just they gotta pay it and then gotta reimburse themselves back from the title insurance company.
This sounds like title insurance is wonderful.
It is good because it helps deals close without having to worry about those like arguments prior to the closing. It's things that happen later, and then you don't have to deal with the seller at that point because the buyer files the claim, and the title insurance company decides if they're going to sue the seller, because they can still sue the seller if they want to recover money, depending on what the issue is. I don't know how that works exactly, because there's no privy to contract, but like, they do it. They usually send, like, if it's a large unpaid property tax bill, like if it's like $12,000, there's a very good chance they're going to send them to collections. And then there's collectors that buy those out of the title insurance companies and pester people to get their money.
On title search, those things doesn't come out?
No, title only has title related things, so things that affect the title. So it'd be like
Effective.
title transfers, mortgages, liens, easements, that sort of stuff. This
So
is
what about the seller's lawyer? I mean, he when he's taking this deal, let's say, as representing the seller, is he checking, asking?
no, I don't check. I don't check the city. If they give me they tell me my tax bill. Here's a copy of my tax bill, and I've paid. I just ask them, like, have you paid these? What have you paid so far for the year? And they're like, yeah, I paid this. And then that's how we adjust it. We adjust on closing based on that. We just rely on the seller telling us the truth there. Because they're agreeing to undertake with the seller and the buyer. They both agree to undertake after closing. It's one of the standard documents to readjust the statement of adjustments, which is a breakdown of the taxes. And that's what title insurance is going after as well after. So no one really checks it. What we're doing now, though, is the vacant home tax. There's like 5 cities now. There's vacant home tax in Toronto, Sudbury, Hamilton. I forgot the other. Peterborough, I think it was one of them. Ottawa. Ottawa's the other one. Those ones we are checking to make sure that there's no vacant tax owing on the property. We have to actually confirm those, and there's 2 ways of doing it. It's actually checking with the online records that, like, City of Toronto has the ability to log in and figure it out. Some of them don't, so we rely on them giving us a screenshot that it's been filed and it says declared occupied or declared vacant, and there's a little screenshot of it. Or the title insurance will step in and provide coverage if there's an affidavit by the seller that confirms they filed their declaration as occupied, or if it's vacant, that they've paid the vacant taxes. So we can get an affidavit on closing, the title insurance steps in and deals with it if it's not true.
What if people haven't filed that declaration in a number of years?
Yeah, so that's happened to us. We do a 1% holdback from the assessed value of the home from the tax bill. So if the assessed value is $500,000, we hold back 1% of the $500,000 until the client at that point after closing can confirm with the city if it's been paid or not for each year, right? So if you said multiple years, so if it's like the past 3 years hasn't been filed.
But say they just didn't file, but they were always living because they're elderly. They didn't have anyone to go online and do that.
So they have to file a dispute with the city and provide the evidence to the city, and the city will usually takes off the vacant taxes. But if it's after closing and you're no longer the owner, that's very difficult to do. I don't know how that would work actually. I think the new owner would have to file the claim. But title insurance probably will step in. If you gave us the right information on closing to satisfy us that you've paid it or you've filed it or whatever, and it turns out that that's not the case, title insurance steps in and deals with them. We're actually dealing with one of those right now where they claim that everything was done. They gave us an affidavit on closing, and then it turned out it wasn't, and title insurance is now dealing with it. So that's out in Ottawa.
I think it's important. How helpful is the clause, where is, the buyer
As is
saying,
where
where
is.
is?
As is where is.
Yeah.
How helpful is it?
For the, let's say the property is completely,
I mean, it's
This-
helpful
this
because
repair-
it sets
how-
the expectations properly between the buyer and seller, but technically it's as is where is if there's no other clause in the agreement. It's buyer beware. Either way. But it's nice because it sets that expectation. Everyone knows it's as is where is. Buyer and seller, right?
Yeah.
You were saying that the number of closings that you're seeing for the next coming months have actually dropped.
Yeah, we had a really good July and August. We got caught off guard with the amount of files that were coming in. But we're, September, October is not looking as promising. So, and this is kind of stems from what you guys see, right? You guys saw April, May jump in number of sales, and then July and August they've sort of tapered off. We get the tail end of that 2 months later, right? 2 months later. Yeah. It's across the board. I don't think it's just you guys. It's everywhere. Yeah. Questions?
Yeah, I have a question as with
Yeah.
regard to, you know, what property listing we are talking about. Before taking the listing on a condo, we check the, you know, the geo warehouse, etc., and we noticed that the title was changed, that there was no wife and husband on the title, there's only husband. And it's happened like, let's say, a year before that. So we were calling, and wife was completely astonished and not aware of that thing. And so they came to that lawyer who did it with the husband, not telling the wife that she's now not on a title. And she was furious. She was really, you know, very upset. He put it back her on a title. I'm just, how does it technically? So one of my question is, okay, when they were buying, I would see we understand what does mean joint tenancy. Yes, the same people, the same property, at the same time. So when he took her off and put it back, is it still joint tenancy, or now is it tenancy in common?
So joint tenancy is a term that basically is about survivorship. When one person passes away,
Yeah.
the property goes to the surviving person.
So now
Tenants in
it's,
common is a percentage of ownership in your specific interest. Husband, wife have 50-50, 60-40. They have to specify what percentage they own in the property. And when they pass away, that percentage goes to their estate. It doesn't necessarily go to the surviving person. In their estate, if they have a will, they can mention in the will who they want it to go to. Or if they don't have a will, it goes to the next of kin. And if the next of kin is the husband, it goes to the husband anyways. But it has to go through the probating of the will and all that sort of, or the estate and all that sort of stuff. So, but when you're saying they put him back on,
he put her back on,
right?
yes.
How did they put him back on? Did you look at title again to see if it's joint tenants or tenant in common? They have to specify how they're going to take title.
Yeah, but then is it still joint tenancy, because now it's not the
Well, I
same
don't know.
time?
Well, I don't know, because it depends on what they put when they registered it. It all depends on how they registered on title. I don't know.
It doesn't necessarily
You
go
pick.
back to what it was before.
The
I think that's what
yeah,
you're
it
saying.
doesn't necessarily go back to what it was before. It's
Yeah.
you pick how to
Can
put
you
it
imagine?
back on
So
title.
Well, the question is, how did she get out without her knowing?
Exactly.
Is there a way?
Oh yeah, you know,
No.
this guy should be disbarred, you know, because this is just.
Oh, he was a lawyer?
Oh, lawyer. Oh, they went to the lawyer,
Okay.
and the lawyer
By
took her
himself.
off the title.
Just
She
without
didn't-
her knowing.
because she didn't sign on it, of course. You had to sign
Well,
it.
I mean, that's not. I don't know. Someone's not telling the truth there.
Yeah.
Oh
Someone's-
yeah, of course the husband.
Like the lawyer would like, so in order to remove the wife, you need a signature from the wife to confirm.
Oh, she didn't know. She didn't know anything.
And again, this is back to having a reputable lawyer. Did someone meet with them to explain to them the documents that they were signing, or did they just sign documents? And you as an individual, why are you just signing documents without even knowing what you're even signing? But a lot of people do it. So, you know, maybe this lawyer didn't actually meet with this wife, and they sent someone out to have their, or maybe with the clerk, and no one explained to them what they were signing, and they just signed it.
No, she told us
And-
that she was completely.
Right,
Maybe
and then this is
somebody-
again, this goes back to, okay, well, what did that lawyer do? We will never know the truth of it.
Yeah.
That's
Could
fraudulent.
Did
a
they-
document be prepared and then the husband takes it to the wife, just between the two of them, and she signs it, and then he brings it to the lawyer?
Yeah, anything's possible.
Is
That
that
lawyer,
possible?
that lawyer shouldn't be practicing like that. If that's the case. That's
He
just,
So
Even
that
what?
shouldn't be.
no, a lawyer should be meeting with their clients to explain to them what they're doing.
But his
No.
client is the guy, is his husband,
Yeah.
let's say.
No, the client is both, husband and wife.
Okay.
If you're removing someone
Okay.
from title, you have two clients. You have the husband
Okay.
and you have the wife. Those are your
Alright.
two clients.
So it's not like the husband could like, does
No,
he go
no.
back into
Well,
the
I mean, it
car
could. I'm
and-
not saying it couldn't have happened, and the lawyer, if they did that, is just super sketchy. And
Okay, okay.
shouldn't be doing stuff like that.
Okay, he explained even to his wife why he did it. He wanted the money to go to his children from the first marriage, you know. So it was really set up. It was not just kind of mistake or
But
something.
again, the wife probably knew.
Okay,
Maybe just making it up that she doesn't know.
Maybe.
yeah, of course we.
Yeah, like, you don't know.
Yeah.
We don't know.
I don't think a lawyer would go to that point where they're not even meeting with the person to remove them from title and doesn't even know that they're like.
Yeah.
You have to be a really bad lawyer to do that. Or I don't know. I've never.